The Criminal Procedure Identification Bill 2022 is in the news. It proposes to authorize police and prison officials to collect, store and analyze physical and biological samples of arrested persons and convicts for criminal investigation. In this video, we will study the bill in detail. First things first, why is this bill required? See, having a repository of crime-related data could go a long way in improving criminal justice delivery. Physical and biological samples are legally admissible evidence. They help the investigating agencies to establish the crime of the accused person. That aids in speedy prosecution and conviction. Speedy justice is important because it acts as a deterrence for potential criminals. The emerging trends in the world of crimes and novel methods adopted by criminals call for the use of the latest technology in investigations. Staying one step ahead of wrongdoers is the need of the hour, and technological interventions would surely help the investigating agencies. Now let us look at the provisions of this bill. The bill proposes to replace the Identification of Prisoners Act of 1920. The 1920 Act allowed only the collection of photos, fingerprints and foot impressions after magisterial order. Back then, the technology to collect biological samples was not available. But today, with scientific progress, we can collect even iris and retina scans. In line with it, the bill expands the list of details that the authorities can collect in addition to photos, footprints and fingerprints. These are palm print impressions, iris and retina scans, other physical and biological samples such as blood, semen, hair samples and swabs, behavioral attributes such as signature and handwriting, or any other examination referred to under Section 53 or Section 53A of the Code of Criminal Procedure 1973. Alright, we have seen what can be collected, but from whom can it be collected? The answer is all convicts, arrested persons, and persons detained under any preventive detention law. A convict is a person found guilty of a criminal offense in a court of law and is serving a sentence to imprisonment. In preventive detention, a person who has not yet committed a crime gets arrested to prevent them from committing a crime. The assumption is that taking them into custody is best for maintaining law and order. Okay, so we saw what and from whom. Now, who can collect details? Prison officers who are not below the rank of a head warder, police officer in charge of a police station, or not below the rank of head constable. What after collection? Here, NCRB comes into picture. The National Crime Records Bureau is an agency under the Ministry of Home Affairs. It collects and analyzes crime data and empowers Indian police with information technology and criminal intelligence. The bill authorizes NCRB to collect, store and preserve data. NCRB can collect details from state governments, union territories or other law enforcement agencies. It will preserve the data in digital or electronic form for at least 75 years. However, if a person is acquitted, authorities will destroy the data. NCRB already operates a project called Crime and Criminal Tracking Network System, in short CCTNS, for creating a comprehensive and integrated system for effective policing through e-governance. Presently, we have extensive facial recognition technology programs for smart policing deployed all across the country. Their integration with state and national level databases, including CCTV footage, can save crucial time during the investigation. A magistrate may direct a person to give details for investigation or proceeding under the CRPC. A magistrate is a civil officer who administers the law. They have a smaller jurisdiction and lesser power in comparison to a judge. They deal with cases involving minor offences. Refusal to allow data collection shall be an offence under Section 186 of the Indian Penal Code. Policing is a state subject. The state government is empowered to make rules on various matters like the manner of collection, storage, preservation, destruction, dissemination, and disposal of details. This bill extends the power to make rules on these matters to the central government as well. The centre and states have the right to formulate laws on data protection and protect the data. Every rule that is made shall be laid before each House of Parliament and the state legislature. Now let us try to understand the issues with this bill. There are apprehensions about the misuse of the bill. The provisions of the bill might violate the right to privacy of citizens. In the 2017 Puttaswamy judgment, the 9-judge bench of the Supreme Court held that the right to privacy is a fundamental right under Articles 14, 19, and 21 of the Constitution of India. Any state action infringing upon the right to privacy needs to be backed by legislation. The bill also allows the collection of biological data of those arrested under preventive detention. It seeks to empower police and court to take measurements of an under trial person. Upon mere suspicion of involvement in a case, and even when there is a presumption against a person that he may commit any illegal activity, authorities can collect biological data. There have been instances of misuse of blanket power by law enforcement agencies. This provision has the chance of being misused against political adversaries. The bill proposes to collect samples even from protesters engaged in political protests. Some people opine that the possible ramifications of the bill include its usage as a tool to curb dissent. It is not in sync with the cardinal principle of criminal jurisprudence, that every person accused of any crime is innocent until proven guilty. It also violates human rights provisions laid out in the United Nations Charter. Given the rate of custodial violence in prisons, there is a high risk of forceful measurement. Moreover, using force to take measurements violates prisoners' rights, as laid down by the Supreme Court in several judgments that you can see on the screen. The average life expectancy in India is around 70 years. The data gets stored for 75 years, which is most of a person's natural life. Questions also arise about the objectivity of the type of information extracted from the accused. Also, will it be acquired righteously and with the consent of the accused? Or will there be an unwarranted intrusion into personal liberty? We know that false testimony is undesirable, since it impedes the integrity of the present trial as well as future verdicts. In the absence of a data protection statute, this bill might do more harm than good. Without proper legal guidelines, there will be no accountability. That will pave the way for intrusive investigations, making the cure far worse than the symptom. It is like giving the police a free hand to gather personal data from more or less anyone they choose. And how will these records be used for preventing crime except through surveillance? Also, it is natural for the police to use multiple copies of measurements. Due to the absence of a data protection law, deletion on acquittal will suffer from weak enforcement. What does the government have to say about these issues? Changing times and increasing disputes have made some acts and codes irrelevant today. One such act is the century-old Identification of Prisoners Act of 1920. The 87th report of the Law Commission of India and the Supreme Court judgment in Ram Babu Misra had suggested the need to amend the statute. That explains the rationale for bringing a bill matching the modern international standards. The database of criminals with identification markers is a global phenomenon. This bill is a much needed change for crime investigation in today's digital age. Machine learning, deep learning, visual search, and face recognition will assist police personnel in identifying criminals. Expanding the scope and ambit of measurements will help in the unique identification of a criminal, thereby making investigation efficient and expeditious. It is high time we upgrade crime-solving technology and bring it in line with global standards. New measurement techniques are being used globally for giving credible and reliable results. The right to privacy is an intrinsic part of the right to life and personal liberty under Article 21 of the Indian Constitution. However, fundamental rights are not absolute, and they have reasonable restrictions. That means, right to privacy is guaranteed subject to national security, public morality and decency, and friendly relations with foreign countries. By the way, do you think that responsible citizens must fully cooperate with investigation agencies? According to the government, the bill has provisions to safeguard human rights. Arrested persons will not be obliged to give their biological samples unless they have committed an offence punishable with a minimum of 7 years of imprisonment or an offence against a woman or a child. As we have already discussed, in case a person with no criminal background gets acquitted by the court, the records will no longer store the biological data, and the authorities will have to destroy it. No proceeding shall lie against any person for anything done or intended to be done in good faith under this Act. What is the way forward? Putting up a bill for pre-legislative consultation is a healthy practice. If adhered to, it can save time and energy. Anyway, speaking of the proposed law, it must pass the test of Article 20, Clause 3 of the Constitution, a fundamental right ensuring the right against self-incrimination. A person accused of any offence shall be under no compulsion to be a witness against himself. An assurance is necessary that there is a proper basis for intervention in the first place. We can have a competent authority who has the power for allowing such extraction of information. Furthermore, there is a need to have an appellate authority that can be approached in cases of misuse of coercive steps by police. We must have proactive measures to eliminate the possibility of class bias. People who lack social and economic power in society must not face harsher law enforcement. It is necessary to maintain a proper database of specialized heinous offenders. We can use the scope of the identification methods only in selected cases involving habitual and professional offenders. Putting them into practice in every case will be a futile exercise. Under the right to be forgotten, private information that is no longer necessary gets deleted from the internet under certain circumstances. Right to be forgotten is an evolving concept and not yet backed by statute in India. The time has come to initiate a healthy public debate on it. In the Selvi vs. State of Karnataka case of 2010, the Supreme Court prohibited the unintentional administration of certain tests like narco analysis, brain mapping, and polygraph tests. It calls for a thorough deliberation on the usage of such forensic psychology-based deception detection techniques. In a polygraph test, we measure different physiological responses like breathing, blood pressure, blood flow during questioning. Based on the variability of those responses and the subject's expressions, we attempt to determine the truth. In narco analysis, we inject a drug into the subject's bloodstream, which sends them into a hypnotic state. It lowers their inhibitions and allows them to disseminate information. Do you think it is right to make a person delusional and make them confess without their full mental capacity? We need steps to ensure that criminal profiling is accurate. Provisions are needed to eliminate the wrong identification of the accused. Implementation of adequate technology can minimize the margin of error. We must preserve a person's right to a free and fair trial or justice in all cases. A nation must strive to be a constitutional democracy and not merely an electoral democracy. So we can conclude that the bill has both sides to it. On one side, it is a necessary measure to strengthen our internal security. Using advanced technology like artificial intelligence and biometrics will bolster crime prevention efforts by making the identification of serial offenders easier. While on the other hand, we cannot ignore the probability of state surveillance and consequent misuse against dissenters. Advanced countries across the globe are relying on new measurement techniques for reliable results. With proper safeguards and meticulous implementation, the bill has the potential to reinforce investigative efforts and overhaul our criminal justice system. Integrated data can help the investigating agencies to prevent criminal activities in the future. It can be a game changer in circumstances wherein it becomes difficult to gather evidence through ordinary means. Intrusion into privacy causes real physical and mental consequences for people. The responsibility to protect individual autonomy lies with each organ of the government, including the legislature and the union executive. We need safeguards to prevent the miscarriage of justice. Implementation must be carried on with the attitude that there is always room for improvement. With this, I sign off for today. Thank you for your time.